Not cry. I did not call a lawyer that night. I sat at my kitchen table in Mississauga with a mug of tea going cold in front of me, and I read the document they had sent through my brother's email like it was a casual family update. It was not casual family update. It was a formal letter from a paralegal in Brampton, notifying me that my parents intended to file a claim in small claims court for $18,400, the exact amount sitting in my TFSA, the exact amount I had been saving for 3 years, working double shifts at the hospital administration office, skipping vacations, eating rice and frozen vegetables twice a week so I could build something that was mine. The exact amount my sister had asked me to lend her 6 months ago, which I had refused. I put the mug down very slowly. I looked at the letter again. Then I looked at the window, at the parking lot lights outside, at nothing in particular. And I thought, they have no idea who I have become. Let me go back. I grew up in a house in Scarborough where the rules were different depending on who you were. If you were my sister, 2 years older, louder, the one who made my parents laugh at dinner, the rules were flexible, soft, forgiving in a way that felt almost generous until you realized what it cost everyone else. If you were me, the rules were enforced with precision. I was the one who got a part-time job at 16 because my parents said it would build character. My sister did not build character until she was 23, and by then the house had already co-signed her first car loan. I was the one who applied for every bursary and student loan available so I could go to Ryerson for health administration because my parents said the money was tight. The money was tight when it was for me. When my sister decided at 26 that she wanted to enroll in an aesthetics program at a private college downtown, my parents paid the $9,000 tuition without blinking. I did not say anything. I had learned by then the specific cost of saying anything. My sister and I were not close in the way people mean when they say sisters are close. We were not enemies either. We were more like two people sharing a waiting room, aware of each other, occasionally civil, fundamentally in competition for a resource that was unevenly distributed. That resource was my parents' regard. She had it. I visited. After I graduated and got my position at the hospital, I moved out and started building my life with the quiet determination of someone who has been told their whole life that they ask for too much. I didn't ask for anything. I saved instead. I opened a TFSA the month I turned 22, and I put money into it every month, like a private ceremony. Nobody knew about it. That was intentional. When my sister called me on a Tuesday evening 2 years ago, she was crying. She had left the aesthetics business. She'd been renting a suite in a salon in North York, and she had debt, not a little debt. Debt from the salon rental, from equipment she'd financed, from a personal line of credit she had opened during the pandemic and apparently never looked at directly again. She needed $18,000. She said she had already asked our parents, and they couldn't do it right now. She said she had asked her boyfriend, and he'd said no. She said I was the only person left. I asked her how she had gotten to $18,000. She said she didn't want to get into the details. She just needed the money. I said I needed to think about it. I thought about it for a week. I thought about the aesthetics tuition I had watched our parents pay without discussion. I thought about the car loan and the time they gave her $2,000 for a trip to Portugal that she had described to me on the phone as a mental health thing. I thought about my $18,400, which I had earned in overtime and evening shifts and by genuinely never taking a vacation. I called her back and I said no. She didn't speak to me for 4 months. Here is what I did not know at the time. While I was going about my life, taking the GO train to work, renewing my lease, quietly learning everything I could about estate law because I had started to sense in the way that people who grew up in unbalanced households develop a kind of radar for imbalance, that something was coming. My parents were working, not working the way people work, working the way families work when they have decided the outcome and are building the paperwork around it. My mother's brother had passed away the year before and left a small amount of money to be divided among his nieces and nephews. I knew about it. What I did not know was that my parents had, at some point, told my sister that the inheritance was being held in my name temporarily for tax purposes, and that I was going to transfer it to her once things were sorted. I had never agreed to this. I had never been asked. I found this out not from my family, but from a conversation at my cousin's engagement party, when my aunt leaned over and asked me warmly and without any awareness that she was dropping a grenade, whether I had sorted out the transfer to my sister yet. I smiled. I said we were still working through the logistics. I went home and I sat with that information for a long time. The inheritance had been $4,200. It was already in my checking account. My parents had, apparently, been telling my sister for months that this money was hers, that I was simply holding it, without ever mentioning any of this to me. It was a small thing, in dollar terms. It was not a small thing. I called my father the next morning and I asked him, calmly, whether he had told my sister that the inheritance money was going to her. He said he didn't remember saying it exactly that way. I said, "Did you tell her the money was hers?" He paused. Then he said my sister was in a difficult situation and family helps family. I said, "I'm family too." He said I had always been very independent. I think about that sentence a lot. I had always been very independent, as if my independence were a personality trait I had chosen, rather than a skill I had developed because I had no other option, as if the $18,400 in my TFSA had appeared there, because I was the kind of person who likes saving, rather than because I was the kind of person who had been shown, repeatedly and clearly, that no one was coming to help her. I said I would think about what he'd said. I thought about it for one evening. Then I made an appointment with a legal clinic at the Osgood Professional Development Office that offered free consultations. The paralegal I spoke with was a woman in her 40s who had the particular energy of someone who has heard every version of every family story and is not surprised by any of them. I told her what was happening. I told her about the inheritance, the TFSA, my sister's debt, my parents' apparent plan. She said, "Do you have documentation of your contributions to the TFSA?" I did. I had every deposit notification. I had my T1 statements. I had 3 years of TFSA contribution room records from CRA. She said, "The inheritance money, is it in your name, transferred to your account?" It was. She said, "Then it's yours. There is no legal mechanism by which your parents can direct you to transfer money you legitimately received as a beneficiary, unless there was a specific condition in the estate documents. Was there? There wasn't. She told me what a small claims court filing would look like. She told me what my parents would need to prove. She told me gently that family court situations involving money almost always hinge on documentation. Who has the paper? Who can show the timeline? Who has the receipts? I had the receipts, but I also had something else now. I started keeping notes. Every conversation with my parents about money, I followed up with a text or an email summarizing what was said. Just confirming our conversation. You mentioned that the $4,200 was meant to go to her. I want to understand where that agreement was made. My mother replied once, flustered, saying it had always been the understanding. I saved that. I called the CRA to confirm my TFSA account details and ensure everything was properly documented in my name alone. I called my bank and added a note to my account file. I did not tell my sister any of this. I did not tell anyone. I went to work. I took the GO train. I ate lunch at my desk and I saved the messages and I waited. The paralegal letter arrived on a Thursday. My parents were claiming that the $18,400 in my TFSA represented funds that had been informally promised to my sister during a period of family financial difficulty, and that my refusal to transfer constituted a breach of a family agreement. There was no family agreement. There had never been a family agreement. There had been my sister asking me for money and me saying no. But here is the part that made me go very still when I read it. They had included as supporting documentation a screenshot of a text message exchange between me and my sister. In that exchange, from 8 months prior, my sister had written, "Mom said you're going to help me out with the debt situation," and I had written back, "I'll think about it." They were arguing that "I'll think about it" constituted a promise. I read that 3 times. Then I took out my phone and I scrolled to that conversation, and I found the next message in a thread sent 4 days later, which read, "I've thought about it and I can't do it. I'm sorry." They had submitted the first half of the conversation and not the second. I took a screenshot of the full exchange. I sent it to myself by email with the timestamp and the subject line. Full conversation thread, unedited. Then I called a real lawyer. Her name was not someone I had known before. I found her through a referral from the legal clinic, a woman who specialized in civil disputes and family financial matters, with an office on Bay Street that was smaller than I expected and warmer, with a plant on the windowsill and a framed print of a lake in Muskoka above her desk. I told her everything. I showed her everything. She was quiet for a moment after I finished. Then she said, "They submitted a partial conversation as evidence?" I said yes. she said, and you have the full conversation. I said yes. She leaned back and looked at me with the expression of someone who has just been handed a case that is going to be straightforward. She walked me through the strategy. In small claims court in Ontario, the onus is on the claimant to prove that a promise was made and that there was consideration, meaning something of value exchanged. An informal family conversation does not constitute a binding contract. A partial text message exchange, when the full exchange shows a clear refusal, does not constitute evidence of a promise. And TFSA accounts are individually registered and protected. They are not joint assets. They are not family assets. They belong to the account holder. She said, they don't have a case. I said, I know, but I want more than that. She raised an eyebrow. I told her about the inheritance, about my aunt's comment at the engagement party, about my mother's text saying the $4,200 had always been the understanding, about the fact that my parents had, for months, been telling my sister that money sitting in my account was hers, without my knowledge or consent, and that this had shaped my sister's financial decisions and expectations in ways that had real consequences. I said, I want them to understand that what they did has a name, and I want it on the record. She nodded slowly. She said she would prepare a formal response to the paralegal letter, a counterfiling that addressed the partial evidence issue directly, and a separate document outlining the inheritance situation and the misrepresentation made to my sister about funds that were legally mine. She said, this is going to be uncomfortable for your family. I said, it's been uncomfortable for me for 30 years. The day of the small claims court appearance was a Tuesday in November. My parents arrived with my sister and the same paralegal who had sent the letter. My sister looked the way she always looked when things were not going her way. Slightly sideways, like she was calculating an exit. I arrived with my lawyer. I was wearing the gray blazer I wore to hospital board meetings. I had my folder of documents, the complete text thread, the CRA records, the TFSA statements, my mother's text message, and a printed record of every deposit I had made into that account over 3 years, with dates. My parents looked at my lawyer and then at me, and I saw something shift in my father's face. He had been expecting, I think, the version of me from 20 years ago, the one who went quiet when things got hard, the one who had always been very independent, meaning the one who had learned not to make noise when she needed something. That version of me had been useful to them for a long time. The adjudicator was a calm man in his 50s who ran the proceeding with the brisk efficiency of someone who has small claims, court at 9 a.m. every Tuesday, and would like to get through the docket before lunch. The paralegal presented their case. He showed the screenshot, the first half of the text exchange. He talked about family agreements and informal promises and the culture of mutual support. My lawyer stood up. She submitted the full text thread. She pointed out, without drama, that the documentation provided by the claimants was incomplete and that the complete record showed a clear and explicit refusal, communicated in writing 4 days after the initial message. The adjudicator looked at both documents. He looked at them for a long time. Then he asked the paralegal, were you aware of the second message when you filed? The paralegal said he had submitted the documentation provided to him by his clients. The adjudicator looked at my parents. My father said he didn't recall the second message. My lawyer then submitted the TFSA documentation, the account registered solely in my name, the 3 years of contribution records, the CRA statements showing the account had been opened and funded entirely by me. She said, there is no legal basis for this claim. The funds in question are the sole property of my client, earned and contributed by my client with no third-party interest established at any point. Then she submitted the inheritance documentation, the transfer record, the estate documents, my mother's text about the money, always being the understanding. And she said, we are not counterclaiming today, but we want it noted that the claimants have, over a period of several months, represented to a third party that funds legally belonging to my client were committed to that third party. This representation was made without my client's knowledge or consent, and it caused measurable harm to family relationships and financial expectations. The adjudicator wrote something down. He dismissed the claim. My sister did not look at me as we filed out. My mother touched my arm in the hallway and said, this didn't have to be like this. I looked at her hand on my arm. I thought about every time I had needed something and been told the money was tight, or that I was independent, or that family helps family in ways that somehow always moved in one direction. I said, you're right. It didn't. And I walked out. That was 14 months ago. I don't speak to my parents regularly now. We have the kind of relationship that exists in texts at Christmas and a phone call on birthdays that lasts about 8 minutes. My sister and I have not spoken since the courtroom hallway. I don't know if that makes me sad. Some days I reach for the sadness and find something else there instead. Something quieter and more solid, like the feeling of standing on ground that actually holds your weight. I still have the TFSA. I've added to it. It's not just a savings account to me, it never really was. It's the record of every shift I worked, when I could have called in tired, every dinner I ate at home instead of going out, every small decision I made in the direction of my own life. Nobody put money into it but me. Nobody can touch it but me. My lawyer sent me a note after the court date. She said I had been one of the most prepared clients she'd worked with. She said most people come in with feelings. You came in with evidence. I kept that note. Because here's the thing nobody tells you about growing up as the family member who is quietly expected to carry things, the same qualities they dismissed as independence. The self-sufficiency, the careful documentation, the habit of following up in writing. Those qualities become something else entirely when you decide to stop carrying and start protecting. They thought they raised someone who would hand over $18,400 to keep the peace. They raised someone who knew exactly where every dollar came from and had the paper to prove it. I keep coming back to one thing my father said during that phone call. You've always been very independent. He meant it as a compliment, I think. Or maybe as an explanation. Either way, he was right, just not in the way he intended. I was independent because I had to be. Because I learned early that waiting for help that wasn't coming is just a slower way of losing time. Every deposit I made into that TFSA was a choice I made alone on a Tuesday evening after a long shift when I could have done something easier. Nobody coached me on that. Nobody co-signed it. I built it the way you build anything when you're not sure anyone else is going to show up. Carefully, quietly, one small decision at a time. What I didn't understand until recently is that this is actually a kind of integrity, not the loud kind. Not the kind that gets acknowledged at dinner. The quiet kind. The kind that means you do the right thing for yourself even when no one is watching, even when it would be easier to let someone else take the wheel. My parents mistook that quality for passivity. They thought because I didn't argue, I wasn't paying attention. They were wrong about that in ways that cost them a small claims court filing fee. The other thing I think about is the text message. The partial one they submitted. I'm not angry about it anymore. I was, briefly, the kind of angry that feels cold and focused rather than hot. But mostly, I think about what it tells you about how this situation was always going to end. When your argument depends on hiding half the evidence, you have already lost. Not in court, necessarily, but in the way that actually matters, you have chosen at some point to build your case on something that isn't true. And the thing about building on something that isn't true is that it holds until it doesn't, and when it stops holding, it stops all at once. My sister is not a villain in the way people want family stories to have villains. She was someone who had been told, her whole life, that things would be arranged for her, and who believed it, the way you believe things that have always been true. The real damage was done long before that courtroom. It was done every time my parents solved a problem for her that she could have solved herself. And every time they handed me a different set of expectations and called it character building, they thought they were helping her. What they were actually doing was making sure she would never develop the muscle you need when the arrangements fall through. That muscle, the one that knows how to document, how to prepare, how to walk into a room with a folder and a clear head. I have it because I built it. Nobody gave it to me. And standing in that hallway after the adjudicator dismissed the claim, I felt something I hadn't expected to feel. Not triumph, exactly. More like recognition. Like finally being seen for what I actually was, even if the only person doing the seeing was me. I don't know what my sister does now with the debt. I don't know if my parents have found another arrangement. That's not my problem to hold anymore. What I know is that I drove home on the 401 that Tuesday afternoon with my folder on the passenger seat and the heat on, and I felt for the first time in a long time like I was exactly the right size for my own life.